day and good evening, everyone, depending where you are. And I would like to welcome you to our mock webinar in which we will try to give you a flavor of dispute board's process. Our mock session is a signature product as DRBF, and we are very happy to share it with you all on this special occasion and to thank you all for being DRBF members, for your contribution to our community, and for sharing your knowledge about dispute boards in your activities. The DRBF is constantly attempting to establish and develop best practice for the DB concept and provide required trainings and workshops for whomever is willing to learn more. I would like to thank in particular to Simon Fagan, the DRBF Training Committee Chair, for developing this and many other mocks and workshops, and to Anne Russo, the DRBF Executive Directors, for organizing it and making it possible. We will be role-playing today with my distinguished colleagues a snapshot of dispute board at work. Today's mock is aiming to illustrate aspects of the various procedural issues that can arise in a dispute board site visit and the manner in which a DB can exercise dispute avoidance through informal assistance. As the narrator, I'll take you through the details of the mock in a short while, but first, the introduction of our cast. Miss Suzanne Rattray, our dispute board today, is a senior engineer with more than 35 years professional experience, has a master's degree in civil engineering, and is specializing in structural engineering. She is listed on the panels of several international arbitral institutions in Africa and also a FIDIC certified adjudicator. Our employer today is Professor Sarwana Harjamul-Jadi, an engineer and a member of the board of directors of FIDIC and of the DRBF Region 2. Sarwana has been awarded with Al Matthews Awards for Dispute Board Excellence. Our contractor, Mr. Levent Irmak, is the former president of Region 2 DRBF Board of Directors, a FIDIC certified adjudicator, a FIDIC certified trainer, and a testifying expert witness. And our engineer today is Mika Tolman, a construction lawyer advising state and sponsors concessionaires and contractors in electricity, national highways, cross-country, and intercity rail, renewable energy, and waste management projects. We are going to use today the medium of a mock dispute board to highlight a variety of procedural issues that can arise in the course of a periodic site visit. Obviously, we won't be able to replicate the entire visit, and we would need to have you otherwise for a couple of days. So we are packing these issues in an hour or so with sufficient exaggeration to emphasize various points. I can say that all these issues have been gathered from real life experiences. Also, although we are presenting this mock on Zoom, we require all of you to watch, imagining that this is a face-to-face meeting with all the participants in one room. In this scenario, the DB site visit meeting has been held earlier in the day, and the contractor raised an issue of a claim that had been rejected by the engineer and that there have been a failure to engage with the employer while seeking a mutually acceptable solution. The contractor gave notice during the meeting that it would now be submitting a referral to the dispute board. The DB requested a short meeting to discuss the procedures involved in the referral of a dispute. We're going to use extracts from FIDIC 2017, which of course has a dispute avoidance adjudication board. And we're using in the conversation the term DB as a generic term. DAAB and DBs are for this particular mock one and the same. But would like to note that dispute boards are also prescribed in other forms of contract beyond FIDIC. And now we are going to listen on the meeting. DB member.
Thank you, everyone, for coming to this meeting. I know we had our PSB earlier in the day, but the reason I've suggested that we reconvene for this meeting is really to follow up on what the contractor announced during this morning's meeting, that it was going to, in his words, give notice of its submission of a referral to the DB. Now, I remember the employer asked that the notice be confirmed in writing. However, just let me say that there is no actual requirement in the contract for a party to give formal notice before submitting a referral. So I consider that maybe this notice is more of an advance warning, and particularly for me, to expect a submission very soon.
Yes, Mr. Chairman, we did that because you're always asking us at these meetings if there are any referrals in the pipeline. So that's why we wanted to bring that up.
Absolutely. And, you know, all of us need to be prepared. And I always want to know in advance what's coming so that I can schedule time accordingly. But really, it's not a contractor requirement as between the parties, the notice of referral. But in this morning's meeting, you also said that you consider that a hearing is necessary.
No. Sorry, I noticed that actually hearing is not necessary in my opinion, because it's just spending more money. We should find another way instead of hearing, because it is the contractor will explain again. Well, actually, it's already rejected by the engineer by clause, FIDIC clause 3.7.
Yeah, but there's certainly a need for us to present it to the dispute court, and you know they're independent and impartial body, and unlike the engineer, who is after all paid by the employer, and of course the engineer rejected our claim.
I reject that insinuation. You know, I might be paid by the employer, but I certainly can make my own determinations. And yes, I did reject the claim, but I would like to say that the claim was really poorly set out, very lengthy, without many paragraphs, and accordingly not really easy to follow the line of argument. And I'm not really sure there was a line of argument. In truth, I thought that there was no substance to the claim whatsoever. And now you are appealing to the dispute board. Well, they will reject it too if they have any common sense.
Look, I think it's we should try and discuss this very calmly. I understand that these claims can be quite difficult, and understand the feelings that they can arouse. But I think it's going to be really helpful for all of us to you know, to discuss it as calmly as possible. Now, the referral.
Yeah, but I mean, our claim, I mean, that's the one that engineer rejected. And now we are, you know, giving you as the DAAB the chance to look at it properly and instruct the engineer to certify the additional monies we are owed. I mean, we have rewritten it with our own, you know, expert claims consultant.
I think what we can do at this point, we can take a bit of time to understand the terminology being used so that we're not speaking at cross purposes here. And I think it's really important that we understand the difference between a claim and a dispute, because under the contract, I mean, either party can bring a claim. That's it's normal. The claims that parties will have claims, and any claim that is brought is determined by the engineer. So should a party bring a claim and is dissatisfied with the engineer's decision, then that party may also, after giving a notice of dissatisfaction as required under the contract, then refer that matter to the dispute board. And I think it'll help us to understand this and to keep the terminology clear in our mind if we use the definitions that the FIDIC 2017 gives. And I mean, you know, we are fortunate that subclause 1.1 has defined everything for us. So if we look at the meaning of a claim under subclause 1.1.6, it defines a claim as a request or assertion by one party to the other party for an entitlement or relief under any clause of these conditions or otherwise in connection with or arising out of the contract or the execution of that work. So in that instance, the claim, as the contractor talks about, this claim is dealt with by the engineer.
Yes, I mean that's our claim, and that's what the engineer did reject.
Quite rightly too.
I think both of you have understood that point in terms of claim, and the claim goes to the engineer, but we need to now think about how a claim becomes a dispute. So the dispute is also a defined term, and the FIDIC 2022 reprint of the 2017 edition gives us a quite detailed definition in 1.1.29 that I would like to refer you to. So I mean, if we can follow together as I read through, it's quite a lengthy definition, but under it's part A, B, and C. If you think about what it says, it becomes quite clear. So one party first makes a claim against the other party, which may be a claim as defined in these conditions, or a matter to be determined by the engineer under these conditions or otherwise. Then B, the other party or the engineer under subclause 3.7.2 engineer's determination rejects the claim in whole or in part. And then the third part, really important, is that the first party does not acquiesce by giving an NOD notice of dissatisfaction under subclause 3.7.5, which is dissatisfaction with engineer's determination or otherwise, provided, however, that a failure by the other party or the engineer to oppose or respond to a claim in whole or in part may constitute a rejection if, in the circumstances, the DAAB or the arbitrators, as the case may be, deem it reasonable for it to do so. So it's important that a referral that illustrates the manner in which a dispute has been come into being, that there's been a process as set out in the contract of a claim and then a rejection and a rejection of the rejection, so that now this claim becomes ripe for the dispute board to deal with it.
So there is no need for a hearing, I think. Hearing is not
we haven't got to that issue yet of whether or not there will be a hearing. I mean, first, we are discussing the process that a matter has to go through contractually. The claim submitted to the engineer rejecting it, and then that rejection is not accepted, then it becomes a dispute, and then that is ripe for submission to the dispute board as a referral.
Yes, I mean, that's all happened, and we have done all these things, and we will include the details of the claim and dispute, the referral, but we still want to have a hearing. We've got a lot of things to say.
Okay, without getting into the details of this particular referral, well, let's talk about procedures, because there can be some guidance in the contract and the procedural rules on the process. And you will know that there are procedural rules at the back of the contract document, which gives guidance on how the DAAB processes work. In particular, if I refer you to the Rule 5, which relates to the powers of the DAAB, and 5.1e in particular. So the parties empower the DAAB to decide whether or not there shall be a hearing. So it's not automatically necessarily in every referral that there has to be a hearing. So the DAAB is empowered to decide whether or not there shall be a hearing, or more than one hearing if necessary, in respect of any dispute referred to the DAAB. So there may be some types of referrals where a hearing is not going to be able to add any more information. It's not going to advance the argument of any party. And matters such as those, they may be decided on a documents only basis. So it really has to be specific to the referral.
Yes, we understand that perfectly. And but again, we want a hearing because we have plenty to say. And at least our counsel will, and with witnesses and exhibits and
So the issue came. You want to throw the attorney to us? Well, we don't need a hearing, I think. Yeah. And we don't want to hear your legal team opinion. We simply reject your claim. Yeah, and also we will reject the referral, as there are no ground to your claim. There is a little need to say anything else. We would like to ask the DB guidance of an issue.
Okay, on the point of guidance, we need to be clear about the type of guidance that DB can give you. So I can tell you about procedure and processes, but I cannot help you with your particular, with your submission. I cannot tell you what to claim and what you can't claim and what whether something is ripe for referral. So process and procedure, I can provide guidance on.
No, we understand that. It's just that we didn't see much point in having to spend a lot of money employing a QS to go through all the contractor cost figures and documents. There must be 40 or so spreadsheet and reams of wage rolls and hundreds of invoices in the quantum claim, which we consider have no ground, and therefore we don't need to bother looking at them and checking the detail, as we consider that there is no new contractual ground with the referral. Then there is a little point spending time, money, and analyzing the cost when we did so to the engineer's rejection of the claim.
You know, I did. I fully examined the claim. There was no ground to the claim. I didn't see much point in examining costs when the claim itself had no merit. We rejected the claim. There seemed little purpose to go too deeply into the exercise of checking all the invoices, etc. There's so much time and money I want to spend on this.
Yeah, but I mean, we don't mind if you don't want to check the cost and just approve them.
Maybe it will be better if we don't turn up at the hearing. Then you cannot proceed in the presence of one party. The DB is always telling us that it must not be in the company of just one party.
I think this is a good point, which to refer to the rules again, because this we have to understand these rules in context. And if we look at Rule 7.1H, that one empowers the DB to proceed in the absence of one party who the DB is satisfied received timely notice of a hearing.
Oh dear, that certainly will not do. We will be there.
So I think I can give a little more briefing about what would be expected in terms of submissions and the parties making a referral. The submissions that a party makes have to be really concise as well as precise documents that set out the circumstances and facts of the dispute, the contractual basis relied on, and the remedies sought. So anything which is coming in the referral, of course, cannot just be assertions. They will require substantiation, could be in the form of extracts from the contract, various copies of communications, and possibly relevant photographic evidence. So likewise, the responding party will need to either agree with what the referring party is saying or rebut the issues and, you know, provide substantiation to support their argument, their point of view. So really, our submissions need to be clear and to the point. Only include what is relevant. Please leave out your life history and all kinds of waffling about irrelevant things. When you make a submission, please make numbered paragraphs, make references to appendices with the proper cross-referencing, put notes so that it's easy to follow what you are saying in the submission. They should tell the entire story of the events leading to the claim, the contractual basis, and the relief sought. You really need to put yourself in the shoes of the DB. It's a very difficult task to try and search through a document which doesn't have proper cross-referencing, trying to find where things are in attachments or appendices or what is being quoted. So really try and be as precise and as well as concise as possible. And also remember that everything that you are claiming or you expect to or hope to be awarded has to be in your submission. I'm not going to be able to deal with anything, make up a relief on my own. So you have to claim what you're claiming. I need to understand clearly what it is that you are claiming, why you think you're entitled, and with all of the substantiation to prove what you're saying. And of course, the responding party must be able to deal with each and every aspect that they wish to reject with reference to any necessary substantiation. So if you think about it, in a contract like this, there's a lot of common documents between you. You can easily create a common bundle of attachments. That's really helpful for a DB so that we don't have 2 copies of everything, big volumes, which are repeating things. So you can imagine if you are making reference to the contract document, I wouldn't need 2 copies of that. I mean, it's a common document. Many of the letters are as between the parties. So those are common letters, minutes of meetings. So you can work together to create a common bundle in terms of that will be referred to the DB with your submissions.
You mean we need to collaborate on this production?
No way. We want our submission to be a surprise.
Of course, you must collaborate. I mean, that's the only way that we are going to be able to resolve disagreements, if we collaborate as much as possible. There are surely points on which we agree, and the points on which we disagree can surely be narrowed. Look, we don't want any surprises in a dispute resolution process. We're not going to ambush each other at the last moment, coming up with something that our counterparty hasn't had an opportunity to respond to. So look, whatever evidence that you have, whatever substantiation that you have, you must put them in with your submission in a timeous manner. I'm not going to allow evidence to suddenly appear at the last minute unless there's very good reason why it was not submitted together with your submission. So please, everything out in the open upfront, and give your counterparty an opportunity to respond.
But how should we respond to all these invoices and Excel spreadsheets? It's a huge task.
I think it's important for both parties to understand that I can't assist either of you with submissions. I cannot make a case for you. I cannot defend a case for you. If you need whatever help you need to get professional assistance elsewhere. So what we can focus on now, I think, is to talk a little bit about the hearing. If one party requests a hearing, and obviously in the interest of justice, we have to have a hearing, and I will set the date for that hearing.
Okay, and we will have lots of witnesses for that.
And our legal team will thoroughly cross-examine them.
If we can just pause for a moment, that there is no cross-examination of witnesses in the dispute hearing process.
That is ridiculous. How can we get them to tell the truth?
Well, our witnesses will take an oath, and of course they are truthful. Witnesses always tell the truth.
No, please. I think we need to be able to distinguish very clearly between a dispute board process and other kinds of adjudicator processes. I mean, witnesses at a DB hearing, they don't take an oath or affirmation. The process of questioning is such that each party may ask questions, but through the chair. It's not a court. There'll be no aggressive questioning or shouting or the kinds of cross-examination procedures that you may see in a court process or even in some arbitrations. I will be asking questions. That's my role. If we refer to the rules, 7.1D allows the DB to be inquisitorial, and the parties with your witnesses can prepare written witness statements, which will come in with your referral submission. Also, I will need the list of the witnesses who will be attending the hearing, and I need you to identify whether they are witnesses of fact or they're expert witnesses. I think the contractor already mentioned earlier that they'd employed an expert claims consultant. So if any party is employing an expert, then I will need written notice of that by a date, which I will confirm in the timetable, which I will shortly issue, so that your counterparty has an equal opportunity, if they so desire, to employ their own expert. And if both parties have experts, I may require those experts to meet together without the party to see if there's common ground, to narrow down the issues between them, and they can report on this before or at the hearing. So this is really going to facilitate a much more efficient dispute resolution process. And now, I think the contractor said that they will bring counsel, and the employer has referred to bringing their legal team. It's important for parties to understand that when it comes to the facts relevant to their current citizen side, I want to hear from those who were involved with the running of site as to what happened. And so all of these instructions I'm going to include in the timetable that I will be issuing to you for the hearing.
Yeah, but I mean, after having heard what you said, I mean, all these things, you know, sound very formal to me.
Well, you know, you must expect that there's some element of formality involved. I mean, a referral is going to result in the DB producing a decision which is having legal consequences on the parties and binding. So there, by necessity, there's a certain element of formality. But actually, the process of a DB hearing is a lot less formal than an arbitration or a court hearing. And it's my role to ensure that the proceedings don't get out of hand and they're not turned into anything resembling a high court drama.
It would have been better if we could have solved all of this amicably then.
Yeah, but certainly that is always the first prize. We need to try to avoid disputes, and we need to try and solve things as amicably as we can. But in the situation that we're facing, we have to think about the practical matters to understand, so that we are clear in our mind what happens if there is going to be a referral to the DB for a decision, and in the particular situation that we're talking about, a referral where there has been a request for a hearing. Now, it would be the contractor's responsibility to make the necessary arrangements for a venue for the hearing. I mean, we'll have breaks, we need refreshments, ensure that there's enough seating. Parties often want to present, make PowerPoint presentations to highlight their cases. So if there's need for computers, projectors, screens, these kinds of things, the venue can be anywhere which is suitable and convenient to all the parties, as well as the DB, as well as, you know, whoever needs to be in attendance, like the witnesses. So there's no reason why it couldn't be in either of your offices or in an independent place. It doesn't really matter, but the parties you need to consider carefully who is going to attend. So other than the main participants, it would be those who can assist the speaker. So we will need the people who were directly involved in the events which led up to the dispute, and then you will have people who can assist them. Of course, having said that, you know, there may be mentees who are the parties have learning about DB processes, and they would also be welcome to attend.
Wow, I mean, gosh, this is getting quite involved. Would it have been simpler and quicker for us to just, you know, request another opinion on our claim with the details, and then we could all go home? I mean,
you raise a good point, but informal assistance is something which is part of the service that a DB provides. But and really, when you think about the most important, the primary purpose of a DB is really to persuade parties to avoid disputes. Dispute avoidance is the first prize.
A little late for that, isn't it? The contractor is about to launch one.
No, it's never, ever too late for informal assistance. So the contract provides for informal assistance under a number of clauses. I mean, even if you look at the subclause 21, which is all about disputes and arbitration. I mean, before we even get to disputes, subclause 21.3 is talking about avoidance of disputes. And you know, just to read, it says, if the parties so agree, they may jointly request in writing with a copy to the engineer, the DAAB to provide assistance and or informally discuss and attempt to resolve any issue or disagreement that may have arisen between them during the performance of the contract. Now, also, if the DAAB itself becomes aware of an issue or disagreement, it may invite the parties to make such a joint request. So, you know, it's something that from both sides, you are free to request the informal assistance, and the DAAB may invite you to request informal assistance. Now, there are some instances, of course, where the DAAB cannot provide such assistance. And one would be, for example, that if we, on the same subclause 21.3 goes on to say, such joint requests may be made at any time except during the period that the engineer is carrying out his or her duties under subclause 3.7, agreement or determination on the matter at issue, or in disagreement, unless the parties agree otherwise. So really, when the engineer is dealing with an issue under subclause 3.7, I cannot give you an opinion on that. And you'll have to, even if there's a referral, you will have to wait for the decision before you have any hints of my thoughts on the veracity of the referral. I mean, if we look at the procedural rules for a referral and the hearing, procedural rule 7.2 says, the DAAB shall not express any opinions during any hearing concerning the merits of any arguments advised by either party in respect of the dispute. So if we have a referral ongoing and there's a hearing process, then again, I cannot provide informal assistance at that time. But if we look back at, the procedural rules dealing with the avoidance of dispute, procedural rule 2.1, it also refers to the subclause 21.3 and provides that the DB may give informal assistance during discussions at any meeting with the parties, such as a meeting like this one. And procedural rule 3.1c, just to emphasize, says that the purpose of these meetings with the parties and with site visits is to enable the DB to give informal assistance if and when jointly requested by the parties.
Well, as the contractor think this process is getting very involved, we think it's a complete waste of time and money. Your claim was over 200 pages, and the cost section had hundreds of attachments. Are we going to go through all this at the hearing? It will take forever, and the hearing will need a week or more.
Yeah, but I mean, those attachments are very important. I mean, those are the copies of all our costs and wage sheets and invoices. I mean, why should the hearing take a week? I don't understand. Why do you need to look at each wage sheet, entry, and invoice?
Because we think many are very dubious.
Dubious? That's such a scandalous statement.
Wait, are we not forgetting that the DB gave its opinion on this very same matter about a year ago and effectively gave an opinion in the employer's favor? Seriously, why are we dealing with this again?
Okay, if we just step back for a moment and remember, when I refer to the subclause 21.3, which provides for DB giving informal assistance, well, it also states that the parties are not bound to act on any advice given during such informal meetings, and the DAAB shall not be bound in any future dispute resolution process or decision by any views or advice given during the informal assistance process, whether provided orally or in writing. So if you remember, the assistance that was originally sought was based on a hypothetical situation. This referral may be based on more detailed facts and circumstances. Indeed, judging by the documents, attachments that you're all talking about to claim, it's certainly much more detailed.
This is depressing. There must be a way for us to shorten the process. None of us can afford to sit in a hearing for a week. We cannot deal with this cost within time limits. Can we extend the time limit, say, by a month?
Under the contract, an extension of the time period for a DB to deal with a referral can only be extended with both parties' agreement.
Well, we cannot agree to this. I think we need to move on.
Look, of course, procedural rules, again, if we look at the procedural rule related to hearing 7.1b, empowers the DB to decide on the duration of the hearing. So I can also refer you to procedural rule 5.1f, which provides that the DB is empowered to conduct any meeting and or hearing with the parties as it thinks fit, and not to be bound by any rules or procedures for the hearing other than those contained in the contract and in these rules. So there is some flexibility, and the DB will make its decision on what the length of these hearings need to be.
Yes, but I understand that we might just end up with a hearing that is too long for the contractor and not long enough for the employer. Maybe we need to find an alternative that would suit to all of us. Don't you think?
Absolutely. Absolutely, but the parties must remember that a DB has a limited period from the date of the receipt of the referral within which to issue a decision or recommendation as required by the contract. And that period is typically 84 days, a FIDIC, or 90 days, could be an ICC process. So it would be almost an impossible task to check each and every entry in the wage and salary sheets and each invoice. It's reasonable to expect that a method of sampling may be undertaken by the DB in order to verify costs. And of course, any such sampling, any such methodology would be described in the decision.
Right. Look, I mean, the costs are obviously a very important part in this referral, but I suppose that the critical issue here is really to establish that we are entitled to them. And doesn't the DB have any idea some of that informal assistance that you mentioned earlier?
I can't believe that I'm going to say this, but I agree with the contractor on this only. We don't want to pressurize the DB chairman here, as this is very important to us as well. Yes, like the contractor said, doesn't the DB chairwoman have an idea? Any idea how to resolve this and to avoid the dispute?
Well, yes, one thing comes to mind immediately to me. I mean, when we have matters where the issues revolve both around merit and quantum, I mean, if the referring party splits its submission between the merits and the quantum, that could be very efficient. Sometimes after a decision on the merits, it becomes very straightforward to settle the issues of costs. So once a contractual liability has been established, so it's very, very possible that a matter could be dealt with in that way.
Yeah, I mean, it would mean a much shorter hearing then.
Yes, and if it is a shorter hearing, we could be having it at the same time as the next site visit in order to keep the costs down, and that could be a couple of days at the most.
And maybe we could then discuss the cost between us, between ourselves, between the contractors and us. Once we have an idea who is liable.
Maybe we could do that.
Well, this sounds like progress to me. I mean, as a final comment in this meeting, I think it's important that the parties know that at any time, even after they make their submission of their papers, even during a hearing, right up to the moment before I'm going to deliver a decision, parties can get together and seek a settlement. So really, I always encourage parties to be thinking about this and to find ways to resolve disputes themselves.
And so time dictates that we must leave the DB meeting here. And so before we switch to Q&A, I would like to summarize on some of the main issues highlighted in this mock. And in particular, the fact that the DB is empowered by the parties through the contract and its procedural rules to decide whether or not there shall be a hearing, to conduct any meeting or any hearing with the parties as it thinks fit, to decide on the date and the place of the hearing, to decide on the duration of the hearing, but also to adopt an inquisitorial procedure during any hearing, to even proceed in absence of a party who the DB is satisfied that it has received a timely notice about the hearing. The DB has the authority to give informal assistance to avoid disagreements and disputes, including facilitation of communications, helping the parties and other relevant people to communicate in order to avoid disagreement. neither the parties and neither the DB are bound by any informal advice that has been given. The primary function of the dispute board is dispute avoidance, and thereafter, where required, to resolve the unavoidable dispute that has occurred. Now, this mock has also illustrated how an effective DB may facilitate the parties along a path whereby the parties themselves will find a solution. Remember that the DB is always proactive, not reactive. And because not every disagreement can be prevented from becoming a dispute, and it is difficult to do so in real life. But you have to remember that the dispute board process really helps. And in order for you to find some statistics that will help you demonstrate your case, look at the manual that is published online. So you could download it as a book at any time from the DRBF website. There is in it a case, a research study that shows you that the DB process has about 94% success rate. Out of 512 decisions recorded, only 32 were challenged. And even less than that, only 7 of these decisions were overturned. So also remember that having a standing DB in place does reduce the number of disputes, because the DB encourages communications between parties, between the main players in the contract, and also, as you've seen today, encourage them to find solution. We also believe that the support of the World Bank and other international development banks to use mandatory dispute boards, standing dispute boards, it is a strong endorsement of the process. And it has been proven again and again that having a standing dispute board in place does reduce the number of disputes. Now, we have a couple of questions or comments, including questions. So I will ask my colleagues to think about. The first one is from Alfonso Pelosi, who says that a common bundle of documents doesn't look feasible. The referral is done by one party. There is no chance to collaboration at this time. May the responding party refer to the same bundle of attachments which was submitted with the referral? In addition, the responding party will add other documents which it deems necessary. I believe we already answered during the mock. Perhaps Alfonso was in a hurry, but I would like to ask Levent to give his opinion, because we have several, well, all of them are experienced dispute board members in our group. So Levent, would you recommend the same bundle of attachments, or?
Well, bundle of attachments, I think if they are prepared jointly by the parties, that would be great, so that it would prevent the duplication of the same exhibits or same documentation. But I also understand the rationale behind Alfonso's approach. I mean, since the referral is made by only one party, there is no possibility of the responding party to know what kind of exhibits or what kind of documentation would be attached to them. But it may be possible, of course, by the responding party to refer to the claimant party's exhibits. I mean, there is no harm in that. I mean, if there are anything more than what a single exhibit by the claimant will be submitted, then obviously the respondent could make another exhibit for that. But yes, my view is pretty much it on this issue.
Thank you. Now, the next question, from Alfonso as well. If both parties want to present experts, may the DAB request that they appoint one common expert, or that the expert would work together to prepare an as much as possible common report? Again, I think that we have answered this point, but I would like to ask Suzanne to comment on this, please.
Yes, absolutely. So certainly these are a suggestion, a practical suggestion that we can make to parties, but my experience is it's very rare that they will want to agree on a single common expert, but certainly it's not something that the DB can force on the parties, but certainly the parties, if a party is going to instruct an expert, I mean, normally the responding party will also want to instruct to make sure that they can rebut. What the DB can do is to request, and this is certainly what we try to demonstrate in the mock, that those experts have a meeting before we have the hearings so that they prepare a common report. So they will have their individual expert reports, and they will sit together as experts and conclude what they agree on as experts, because there are some things that certainly experts can agree on, especially technical things. And then there will be areas where their opinions may diverge, and they will highlight those things. And those will be the issues that would be interrogated at the hearing. So it's important. I think what we can do as a DB is to instruct that the experts are able to meet together to come to a common conclusion on what they agree and what they don't agree on, so that we can focus our minds on resolving the issues, based on the opinions that they have.
Thank you very much, Suzanne. Now, the next one is for both Sarono and Mika and their experience with employers. So it's from Joe Kelly, who says, in respect of the fee for the DB, many employers consider it is an expensive luxury. Is it? And why it is necessary apart from being mandatory under the FIDIC contract? Many employers amend the contract to delete this requirement with the above thought in mind. So please give it a thought. And Sarono, you go first, and then I'll ask Mika to add his comments. Thank you.
Thank you. Before, in my country, before, the employers always think like this. That this is very expensive, everything, and also there is no legal shelter. That is the problem. And they said, it's not necessarily a TP. And sometimes they delete this one from the contract. But surprisingly, why? When they delete the contract and submit to the lender agree on it. Yeah, no support from the lender. Yeah. And then, but actually, after we conduct the dissemination to all the employers, now they understand the importance of TP and the benefit of using TP. Because we also put this in the law of Indonesia, and now people work on it. Yeah.
Thank you, Sarono. Mika, your experience?
Thank you. Similar to Sarono's experience, at first contractors and employers used to ask, why have the extra fee here? And with time, they started learning the benefits of, the costly expense of a dispute, and they've started to treat the cost as a kind of insurance premium that helps to avoid, the escalation of disputes and the frustration of the projects. And we're starting to see more of an appetite to absorb this cost, especially in more complex and drawn-out projects.
Thank you. And we are coming close to our ending point. I would like to thank very much our colleagues today, Suzanne, Leven, Sarono, and Mika, for being so keen in helping the DRBF region to offer this to all the DRBF members in the world. And I would also like to thank everyone who was attending with us today and invite you to our first live event of 2024, which is the DRBF Central Eastern European Countries Conference on 13th to 15th of March in Sofia, Bulgaria. Meanwhile, please keep looking at our event calendars for other webinars and for other events. Thank you very much indeed to everyone, and have a lovely and great new year.
Thank you.
Have a good new
Thank you. Bye-bye. Happy New Year to all.
Happy New Year.